All right, welcome back. This is the capsule on Quebec's Bill 21. And of course, this is all after the midterm exams. We're done with the portion of the course where, where first we actually learn things that you're being tested on. And second, right, where we learn more kind of doctrinal things, right? So we really made a point of looking at what the law is, right? So unlike other people, perhaps in the department, I actually think that students from other concentrations, right, who are not necessarily in the legal studies program, can and should learn law, right? Can and should learn what the rules are, what the tests are, how the laws are being applied by the courts. And I don't think it's something that's unfathomable, right, in a way that only people who are doing that all the time can understand. For that third of the course, right, the last third of the course, we maybe take a bit of a step back. So we consider, right, some other issues, not just about, right, what the law says, how that's evolved over time, but also about, right, more broadly, what interplay of other social issues do we see at play, right? How does the law do other things then, right? Set rules and boundaries. How does it express who we are? How does it express who we want to be and don't want to be? And we see that reflected in the readings for this week, which are obviously articles by none other than me. So again, you're not being tested on this. There isn't really anything to learn or to necessarily take away, or anything really that you have to agree on in any of what I'm going to say now. I'll take you through some of the issues I discuss in the papers, obviously not in that much depth because you're going to have read them before class, of course. But really, right, the two papers do the same thing. One of them really kind of sets out the ideas more summarily, and then the other one supports it with a different framework looking to the criminal law. And I think the criminal law is interesting for us to look at because it expresses, of course, as I mentioned in the second paper, right, shared anxieties and various identity factors. So what we see in the criminal law is, right, who we are, and more specifically, who we don't want to be, who we're afraid of being. And in that sense, right, we touch upon some issues that we saw under Section 15 jurisprudence regarding identity, right? So Supreme Court recognizes multiple times that, right, first, Canada is a country that's committed to substantive equality. We saw, right, different paradigms perhaps in the United States with the Gratz v. Bollinger case. We saw that for the Supreme Court, it's important in our identity, our judicial legal identity in Canada, to be committed to substantive equality. Significantly as well, right, Section 15 is about facts of our lives that we can't change, right? So the test for an analogous or for an analogous ground, right, which you compare to an enumerated ground under Section 15 of the Charter, is essentially something you can't change, right? So in proving that something is analogous to, say, race or gender or age, right, we'll look at what race, age, and gender mean, and what they mean generally are characteristics that either, as the court says, we can't change, or we can only change at an unreasonable cost, which is this, as we said, maybe a bit peculiar formulation that wouldn't come across today in the same way. But basically things that are important and crucial to our identity. And we also saw the court recognize, both under subsections 15.1 and 2, that we can have, right, mutually, right, constitutive factors in our identity, right? We can have an interplay between various facets of our identity that define who we are, and also define the barriers that we face in life, right? So the court recognizes that some people face discrimination cumulatively based on gender and age and race. And that's also important to substantive equality, and it's important to, right, the ameliorative purpose under subsection 15.2. So what I try to do in the first paper is, right, challenge this idea that Quebec's Bill 21 is about what it says it's about, right? So Quebec's Bill 21, right, as you all probably know by now, forbids public servants, so generally people working for the state. There's a very broad definition there, right? So typically, right, similar laws that would ban religious coverings, often religious face coverings, particularly in Europe, right? Often these would focus on people who are in a position of authority. That's kind of the paradigm that we're afraid of, and it's very European in nature. And of course, Quebec has, right, his ties to France, where these laws are very, very usual. So this idea first of how we conceive of neutrality, right? So neutrality is not about, right, you having your own religion and not imposing it on me. Because you have a right under the Canadian Charter, right, to practice your religion. You also have a right to advocate for your religion, right, to go out on the street and try to convert people. That's one of your rights under freedom of religion. However, we don't want you to force people to join your religion because we think that's bad. Whether you as the state, or you as a person, or you as a person acting on behalf of the state. This idea of secularism, which comes from Europe, right, comes from a European conception, says, well, when you show your religion, and you're in a position of authority by virtue of your role for the state, then you are imposing your religion upon other people. So in other words, right, if you go to the SAAQ, right, you go to the office to get a Quebec's driver's license, and the person who's serving you there has a hijab, right? Well, we might think that's okay if that person isn't actively doing anything to convert you. But that conception of secularism says the opposite. It says, by virtue of that person having authority, namely authority by virtue of the fact that they work for the state, that person, right, is kind of implicitly, right, inviting you to have their religion, and as a result of that, it is not neutral. That's kind of the conception that underlies Quebec's Bill 21. And of course, it's easier to understand in certain contexts, right? Specifically, you might think about education. So even if you disagree with the paradigm I've just set out, I disagree with the paradigm I've set out, right? You might understand that. It probably makes a bit more sense to say if a kid goes to school, they're more likely to be influenced by the religious, quote, symbols worn by their teacher because they're in a vulnerable position. And so you have this interplay of both, right, vulnerability, immaturity, and authority. But Quebec's Bill 21 applies throughout the state to people in positions of authority, has a very, very broad definition of people in positions of authority. Interestingly, it doesn't apply to healthcare workers, arguably because it would have been a problem. You would have banned too many healthcare workers and couldn't have the health system working. Very explicitly, we see at the beginning of the law that it's about promoting the equality of men and women. So why is that important, right? Well, because we see this idea of secularism being, right, not the goal in itself, right? In other words, we don't ban religious face coverings, and again, this is all religious symbols, but of course, right, the most significant, quote, ostentatious religious, quote, symbol, you see lots of odd French translations there, right, is the hijab, right? Because Christians don't have something that they wear almost universally by virtue of their faith, right? They don't have this huge cross, say, that they have to wear on their neck to be in keeping with their faith. And that's different from Muslims. So there's this undertone there of, right, Muslims. And we'll get back to that later on. So secularism, as I said, is not the goal in itself. Even though it's underlined by the paradigm I've just mentioned, it's not the goal in itself because, right, because what we want to achieve with that, right, and we see that in the preamble, among other things, is the equality of men and women. And with that undertone I've just mentioned, right, we think that, right, women, generally Muslim women, are being forced to wear a religious, quote, symbol, that is the hijab, and that violates the equality of men and women, and, right, the neutrality of the state. And so secularism is not the goal in itself, as I mentioned, right? And so the public debate has been focused on, right, whether or not that is correct, right? Whether or not Bill 21 does successfully achieve, right, or seek to achieve that purpose of furthering the equality of men and women. Some people think it does, some people think it doesn't, right? Some people think, right, when you are forcing Muslim women not to wear the hijab, right, in that case, yes, it does, right, quote unquote, free them, right? So the state kind of intervenes for their benefit, and people who are opposed to it are going to say, right, even though you want to promote the equality of men and women, generally, right, women are going to prefer to wear it instead of going to hell. I'm grossly oversimplifying things here, and therefore will wear it anyway. And the only thing you're going to do is you're going to make them lose their job within the public service, and also prevent them from accessing public services, because the other place you can't wear religious symbols is in accessing certain public services. And we have a conception of equality there that's different from the one we saw in the Charter, right? This idea of equality being not just, right, you not forcing your religion on other people by using your authority, but more specifically, right, equality being everyone being the same, right? This is kind of similar to the formal equality paradigm that we discussed, and arguably one of the reasons why, right, the Quebec government is going to use the notwithstanding clause, basically going to preemptively say the Constitution, the Charter, does not apply to this bill. So this idea of equality, treating everyone the same. Second thing I want to mention briefly there is this idea again of Muslim women, right? Again, you have a law that's facially neutral. So you don't have a law that says Muslim women don't get to wear their hijab, right? These are laws that we see in Europe phrased that way. Because in Europe, again, right, not that people don't have constitutional rights, that, you know, Europeans don't care about equality, but we have different conception, right? We think that these kinds of laws in Europe further equality, further neutrality, and therefore, right, it's not about, right, we don't care about equality. Instead, it's about, right, our conception of equality, even in a constitutional sense, is compatible and served by what you're trying to do with a law that says women can't wear a hijab. Arguably, right, Quebec government was smart there, did not write the law that way, made it facially neutral. That doesn't necessarily subtract it from constitutional scrutiny, as we saw, in fact doesn't. However, right, if the law had on its face discriminated against women, so drawn a first distinction, right, second based on either gender or religion, these are grounds, right, then it would have violated subsection 15.1 of the Charter, would not have been saved under 15.2 because obviously it's not an ameliorative program in the sense that we saw under the relevant Supreme Court tests. And what I try to do in the second part of the first paper is, right, to kind of take a step back, to say, what if this is not really about the equality of men and women? What if the law, right, and this is the thesis of both papers, right, what if the law doesn't try to do something, instead it tries to say something, right? It tries to protect and constitute our identity. And I trace this history of Quebec, right, and I'm not the only person to have thought of that. There's people who agree with me, right? This historical influence of the Catholic Church, which is very specific to Quebec. So we see the Catholic Church having a very significant influence, right, including on the state, and people feeling oppressed by it, and feeling a necessity, right, to break free from that influence, very literally, right? The social movement where Quebec, quote unquote, breaks free from that in French is called a revolution, quite literally, right? Quiet revolution, so a little revolution, but still the word is very indicative. And so, right, Now the influence of the church has become oppressive, right? We have the priest come to our house and tell us how many kids we can make, and then they run the healthcare system, and then they run the education system, and then, right, when the premier is in his office, the only people who are advising him are people from the church. And so we think that's oppressive. And as arguably social, right, mores and values move past what is advocated and accepted by the church, then it gets even more, right, creates even more of a chasm that requires us to break free from it. And so that was just a couple decades ago, and I argue that we retain this need, right, as Quebecers, to move away from that legacy, right? First, because we have not fully, right, gotten rid of the influence of religion on the state, because that's what this whole thing I've just described is all about, right? It's about the Catholic Church being, right, in bed with the state, being involved in all aspects of our life and of our public life. And what we want is to kick out the Catholic Church and to kick out religion from the state. And we discussed in the reference case, for instance, right, the interplay of law and religion, right? We said marriage really is not about religion. That's what the Supreme Court said. So you having a legal, right, statutory, right, government passes a law that says you can get married, this has nothing to do with you getting married in a church. The church doesn't have to welcome you. They don't have to marry you. They don't have to have you be a member of their religion if they don't like you, including if they don't like you for discriminatory reasons, because, right, you're a guy, you're a girl, because you're gay, whatever it is, right? The freedom of religion allows for discrimination on these grounds in that specific context. Marriage is about the state. Marriage is about the government recognizing your unions and then attributing a bunch of consequences to that union, generally having to do with, right, support payments, division of property, and so forth. But the reason why people are so opposed to, right, a redefinition of marriage, and we saw a United States case illustrating that, right, very recent, by the way, about 20 years later than the reference we read. The reasons people are afraid of that is because it's called marriage, and the reason it's called marriage is because it has a religious undertone, right? Before, marriage was a bunch of legal consequences. Marriage was a religious concept, and the state said, well, right, we recognize that people are getting married, and they're doing that for life because the religion says it's what they have to do, and therefore, the reason we recognize that union in the first place is because of, right, its religious underpinning. So this interaction between law and religion, which is, right, just one example, but far more complex than we think. And here we see with Quebec's Bill 21, right, this idea that religion and the state should be separated, and so that this interaction, right, is intrinsically bad or oppressive. And if you take this argument further, not particularly important, but you might say, right, that furthers a certain sense of equality because, right, because people, right, if the state is dominated by a particular religion, then, right, will be forced to, right, will be forced to adopt that religion. Additionally, right, there's a sense of a shared identity that's being threatened. Because religion is an important part of who we are as individuals. But there's also transcendental characteristics about who we are that don't have to do with religion, and in fact where religion, right, might differentiate us. And so there's a sense there of a shared identity, right? One of the things that's discussed in the second paper is, right, the Commission on Reasonable Accommodations in Quebec. This was a big thing for about 10 years, right? People were very afraid that certain religious groups were asking for too much, right? This idea that somehow, right, kids were going to bring knives in schools, and then you couldn't ID people at the airport, and then it was going to be awfully dangerous, basically. That's what people were afraid of, and they had this commission with very important professors trying to strike a balance in what is, quote, a reasonable accommodation and what is not, right? Well, underlying this idea is, that our collective identity, so the things that bring us together, say we believe in the equality of men and women, we believe in the fact that people should have access to equal opportunities as much as possible. We believe that if you make a lot of money, you should pay taxes to help people who are disadvantaged, These are things that generally most people agree on, that kind of underlay our project as a developed country. And there's an idea there that if we give religious organizations too much, they threaten that identity, It doesn't mean, that's the conception in Quebec at the time, it does not, mean that you're a Canadian when you're living on your own, When you have your little school, you don't let in women, And you do all these things that might be, that might disrespect our shared values of equality of men and women, And all that. That threatens our identity, and that's kind of first beyond what we can do in a developed country, In a developed country, we accommodate you because we think religion is important, but if you start asking for too much, then you're not really living in Canada anymore, and we don't want you. That's basically, the underlying debate. And so, and this is all, sorry, just take a step back there, this is all very constitutional in nature, You can see that as a debate between various constitutional rights, At some point, you're going to have to balance constitutional rights. In that case, you're going to have to balance the religious rights of minorities who want to do certain things, which might otherwise be either illegal or even unconstitutional, Might violate the right to equality and to be free from discrimination, I said a lot of times in this course that religions discriminate all the time, Discriminate in the sense that's unlawful pursuant to Section 15. However, we think that these violations should be weighed against other constitutional rights. And so, for instance, we think that people should have freedom of religion in Canada, but only to the extent that they respect, say, the equality of women, Or only to the extent that, they don't impede, they don't violate other people's constitutional rights too much, because there's a balancing act there. The other point I want to emphasize is, in my second paper, this idea of fear. So in the criminal law, we have laws that are specifically, about denunciation. In other words, laws that don't try to achieve something. So most of the laws we saw under Section 15 were about, you want to make people more equal by doing this. Or you want to do something else, and that potentially violates the right of people to equality. But the law does something, usually. It doesn't just say something. But we see that in the criminal law, and that's discussed in my paper. We see laws that don't do something concrete. So we see laws that say, we're going to punish you for this because we think it's wrong. Two examples I give are homosexuality, So we've had for way too long in Canada, It's going to scare you if you start looking at the dates. Sodomy laws. You know what sodomy is. I won't explain it, and I think I already did explain it in another capsule. But you know what sodomy is, And that was a way to criminalize homosexuality for obvious reasons. And on top of that, if you're asking the question, government also created an exemption for married people doing it in their bedroom. And so it really was about criminalizing homosexuality. Well, what does that do? Certainly it doesn't protect us in the sense that the criminal law usually does, And again, some of this can be challenged, but generally that's the conception under the criminal law, We don't want people to kill people, and so, if they do it, we'll put them in jail for a long time. And then that's first going to deter them. That's one of the objectives in the criminal law. So in other words, they're going to think, oh well, I might kill people because I don't care about anyone's emotions, but I don't really want to go to jail for 30 years, and so I won't do it. That's deterrence. And second, right, we want to isolate people. Once you do kill people, well, you might do it again, and therefore if you're in jail, you won't do it again, and so we're protected. But that, in both cases, what we're trying to do is to protect society, because killing people is intrinsically bad, and therefore we don't want people to do it, and so we will pass laws that hopefully will proactively make it less likely that people will do it. What about homosexuality there? Well, homosexuality isn't dangerous, right? At least not even in the public conception at the moment it was decriminalized, right? So homosexuality isn't dangerous. At the time, people just thought it was bad. And there's a sense there that the law should reflect underlying social values. That somehow, if we decriminalized homosexuality, it would become okay. We see the same thing with drugs, right? Criminalizing drugs does not work. Specifically, criminalizing drug use does not work, right? It just doesn't make sense. You have someone who's a drug addict or suffering, right? They overdose, and then you put them in jail. That makes absolutely no sense. Doesn't serve anyone, and frankly, people who are overdosing on drugs are not dangerous to other people. They're dangerous to themselves, right? So why in the world are you putting them in a jail cell instead of a hospital? And what I just said is obviously borne out by data. We know for a fact it doesn't work. And we know that from common sense as well. However, right, we have a sense that somehow the law should prohibit that because it is bad. And so a sense that the law isn't just about rules that do things, because of course it is, right? But also that the law, right, recognizes the importance of certain things in society and the lack of importance or the danger of certain things in society. And so in both cases, the underlying idea was if we allow homosexuality and or drug use, right, it'll send a message. So the law here doesn't do anything. In fact, it might do something bad. So in that case, might put sick people in jail, which is not something that's useful to anyone, right? But the cost of that is worth it because the laws, right, communicate a message, namely that drugs are bad or that homosexuality was bad. And we don't want the decriminalization first to say that it's not bad, because then there's going to be an erosion of our identity in the sense that we see it in the criminal law, right? A threat to that shared identity. And second, because there's an idea that somehow then everyone will start doing it, right? That somehow the decriminalization is going to encourage people to do it. And I argue that we see the same thing with Quebec's Bill 21. We see in the relationship that I've described with the Catholic Church, we see an anxiety, right? An anxiety that we're not too far around the corner, right? We did get rid of the Catholic Church, but we got to be careful. We got to be careful because the work isn't done, right? The work of, right, making the public service more secular isn't done. And also because, right, we don't want it to come back. And we don't want it to come back in another form. The other form being specific minority groups getting too many rights and having an influence, right, upon the state, right, or a threat to our shared identity that becomes similar to the influence of religion that was formerly held by the Catholic Church. And if we construe it that way, we also see, right, a similar cost, right? So the cost of preventing Muslim women from wearing the hijab there, right, which, as I've described for lots of opponents of the bill, is very significant. It's significant because they lose access to jobs in the public service, and they lose access to public services, and we see a continued marginalization, right? That's why the bill might have been, right, by the way, unconstitutional, otherwise unconstitutional. So You'll recall I said it has a notwithstanding clause. We'll look at that later on, right? But the bill, right, obviously doesn't specifically draw a distinction based on religion. So I said earlier, could have said, right, Muslim women don't get to wear the hijab. That would have clearly been a distinction based on gender and religion, right, which were grounds, and therefore it would have been discriminatory because it would have played into the historical disadvantage of Muslim women, and wouldn't have been particularly hard to show that Muslim women have traditionally been marginalized in Canadian society. Here, law is facially neutral, right? First, you can argue the same thing based on effect, right? So you might say, right, in the same sense of the general programs that we saw, right, you might say the law says no one can wear religious symbols, but in actuality, only Muslim women do, or, right, Muslim women do because they need to, right, in a way that other religions don't need to, right? So the taking away of that ability to wear your religious, quote, symbol is more significant for Muslim women because it has, right, consequences within their faith and their relationship with God, etc. So in that sense, you might argue it's discrimination in the same way as if it were not facially neutral. So discrimination based on gender and religion. However, you can also look at the effect of the law in establishing that disadvantage, right? So, of course, this is a law that, right, draws a distinction. And why is it discriminatory? Because it plays into historical disadvantage. Not because, right, not wearing your hijab plays into historical disadvantage, because the government sure would argue that it does not, right? Sure would argue that it's good for Muslim women, makes them less disadvantaged because they don't get this oppression of having to wear it. But the argument here is that, right, the impact of it means that they do things, right? So the law doesn't say Muslim women don't get driver's license, but the effect of the law is, right, so if you make them not wear their hijab, their decision will be to wear it anyway, and therefore they won't get access to the benefits under the law. And so it's not equal benefit of the law, and potentially a discriminatory distinction within the sense of the law v. Canada test rate, and therefore in violation of 15.1 of the Charter. As I've touched upon this idea of identity, right, this idea of laws that don't achieve certain things, which is very interesting, right? So this narrow conception, of course, constitutional laws often try to achieve certain things, right? Namely, to not have laws passed that violate the Constitution, but that's very narrow, right? It's a very narrow subset of laws, right? And it's a very narrow subset of what laws do. And I hope we see that in my papers. One of the last things I want to discuss is this idea of the notwithstanding clause. You'll recall I discussed it earlier in the semester very briefly, right? We didn't look at a case that says that applies the notwithstanding clause, but basically you have a clause in the Constitution that says a law can apply notwithstanding the Constitution. In other words, a law can apply regardless of the Constitution, subtract itself from the application of the Constitution. Seems pretty weird in the first place, right? Because really, why do we have constitutional rights in the first place? Because there's rights that are so important that they should basically never be infringed upon, except if you have a really good reason. And that's what 15.2 does, it's what Section 1 does, as we saw, right? Well, here, the government doesn't have to have a reason at all. In fact, it doesn't even go through the steps because the law just says Constitution doesn't apply. So you don't even have any sort of a constitutional analysis under either of these sections. So it's kind of weird, especially if we think of the fact that the Constitution really, right, protects minorities from oppression, right, protects minorities from majority rule, and majority oppression, right? The majority might think it's good for minorities not to have rights. The majority might think we don't want to spend any money on things that are good for minorities. Majority might think, right, we want to take property or things away from minority groups, right? And that's bad, and that's what the Constitution's there for. The reason we have the notwithstanding clause is for historical reasons. Because Quebec didn't sign the Constitution, and so there's a historical compromise there, specifically with Quebec being, right, subject to the Constitution it didn't sign. In a sense, the legislator, right, who did pass the Constitution in 82, basically limiting themselves for generations and generations, basically forever, should have the ability, right, to do certain things notwithstanding the Constitution. And so even if Bill 21 does seem to violate Section 15, you don't have to agree with me, but I think it's pretty obvious, right? Then, right, it doesn't even matter because there's a section of the Constitution, of the Charter, that says the Constitution can apply, the law, can apply notwithstanding the Charter of Rights and Freedom. And specifically, there's this is mentioned briefly. Again, you can look into that in your own time if you think it's interesting. I certainly think it's interesting, right? You still have people contesting the law in court, and in fact, a lot of groups and theories trying to do that. And the theory they're advancing is not relying on the sections of the Charter that you cannot, that you can override. So 2 and 7 through 15, you'll recall for oversimplification during the term I said most or all constitutional rights are subject to the notwithstanding clause, right? Not exactly true, mostly true. And so the theories there are about first separation of powers because that's not subject to the notwithstanding clause. So we saw a law, I think, regarding Aboriginal health, right? And we said health is a provincial field of jurisdiction, and therefore provinces have to pass laws on health, not the federal government. And so if the federal government passes a law on health, it's an ultra-virus law. It's a law that goes beyond its authority pursuant to 91 and 92 of the Constitution, not the Charter, the Constitution, right? And therefore it's not valid. As we saw, government can do other things, can say, here's $1 billion, but do this. That's a regulation of health that's allowed. The government can't pass a law on health directly. Second, there's an argument being made, very interesting, right? There's a provision that says that the rights in the Constitution are equally guaranteed to men and women. And that's not prima facie a provision that has independent standing. Namely because 15 says that. 15 basically says equal benefit of the law. One of the grounds for that is gender. And so 15 says equal benefit of the law for men and women. So if you have another section that says the rights here are hereby guaranteed to men and women equally, right? Well, that does not have independent value based on how it's drafted, based on where it is, but also based on the fact that 15 does that. That's one of the provisions, with the other ones I just mentioned, that they're trying to use to contest Quebec's Bill 21, regardless of the fact that it uses the notwithstanding clause.